This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we speak about why a mold suit, even with a mold exclusion, must still be defended, because an equally fair interpretation favors the insured always, at least in the state of New Jersey. WCPP Risk Purchasing Group asserted coverage claims under a Commercial General Liability Policy issued by the Defendant, Lexington Insurance Company, on behalf of the Village of Stoney Run, LLC, seeking defense and indemnity from an insured who claimed a mold exclusion defeated coverage. In WCPP Risk Purchasing Group, Inc. versus Lexington, the Superior Court of New Jersey Law Division, on November 29, 2023, resolved the coverage dispute. The underlying action alleged negligence, breach of the warranty of habitability, and breach of contract, asserting injury and damage claims against the Village of Stoney Run due to toxic fungus mold infestation in Pratt's apartment. It asserted that the mold caused the death of Pratt and damaged her personal property. Plaintiff purchased the policy on behalf of the Village of Stoney Run as part of a joint purchasing group. WCPP is a risk purchasing group for primarily habitation and commercial real property locations. The underlying action was initiated by Brian Pratt and Dawn Pratt, the co-administrators of the estate of Darlene Pratt, against the Village of Stoney Run, an apartment complex owned by Blesnack Organization. As part of the action, the underlying plaintiffs asserted claims of negligence, breach of warranty, and breach of contract arising out of allegations that plaintiff failed to properly maintain and repair defendant's apartment at the Village of Stoney Run, resulting in dangerous living conditions, including mold that resulted in death. Suit in the underlying action was forwarded to Lexington. AIG Claims, Inc., working for Lexington, issued a disclaimer of coverage on behalf of AIG Property Casualty, Inc. and Lexington. That policy of insurance disclaimed coverage based upon the fungus mold exclusion contained in the insurance policy. The court must enforce the clear and unambiguous terms of the policy of insurance. A policy of insurance is ambiguous only where reasonable, intelligent persons would differ regarding its meaning. The court places the obligation on the insurance carrier to draft clear and unambiguous contracts. Where the policy language will support two interpretations, only one of which will support a finding of coverage, the court will choose the interpretation favoring the insured and find that coverage exists. Lexington asserted that the policy of insurance contains a mold exclusion which precludes coverage for the claims in the underlying suit. That exclusion provides, quote, bodily injury or property damage or any other loss, cost, or expense, including but not limited to losses, costs, or expenses related to, arising from, or associated with cleanup, remediation, containment, removal, or abatement caused directly or indirectly, in whole or in part, by 1, any fungus, mold, mildew, or yeast; 2, any spores or toxins created or produced by or emanating from such fungus, mold, mildew, or yeast; or 3, any substance, vapor, gas, or other emission, or organic or inorganic body substance produced by or arising out of a fungus, mold, mildew, or yeast; or 4, any material product, building component, building, or structure, or any concentration of moisture, water, or other liquid which within such material, product, building component, building or structure that contains, harbors, nurtures, or acts as a medium for any fungus, molds, mildew, yeast, or spores or toxins emanating therefrom, regardless of any other cause, event, material, product, or building component that contributed concurrently or in any sequence to that bodily injury or property damage, loss, or expense. Close quote. The claims in this case arose from water leaks, which resulted in the conditions about which plaintiff's decedent in the underlying complaint bases the cause of action. The court concluded that the interpretation of the mold exclusion by plaintiff that the loss was due to the water leaking, not mold per se, is equally reasonable to the interpretation of the defendant insurers. Under the circumstances, it is the interpretation most favorable to the insured which controls in New Jersey. Accordingly, the court concluded that coverage exists for the exposure to mold as a result of the water leakage. In my opinion, courts interpret insurance contracts differently than other contracts. If a court finds an ambiguity or is here an interpretation of an exclusion by the insured and the insurer that it believes are equally reasonable, the interpretation of the insured will be enforced. Paraphrasing George Orwell in his novel Animal Farm, all litigants are equal. Some, the insured suing an insurer, are more equal than others, like his insurers. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog as you should. The blog is available for subscription free, and you will get notice of every blog post, usually 5, sometimes 6 a week, and access to the more than 4,650 blog posts. You can also subscribe to my videos on youtube.com or rumble.com, all of which are free. And if you do, I'd appreciate it if you click on the like button on YouTube and or the thumbs up button on rumble.com. Please tell your friends and colleagues about the videos, and please subscribe. And if you're interested in further details about insurance, insurance law, insurance fraud, and insurance claims, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.